The Defense of Marriage Act, passed during the Clinton administration, basically said that same-sex married couples were not allowed. It was basically two big parts of this. One, they were not to receive the benefits that heterosexual married couples receive in terms of nearly 1,000 federal laws that implicate marriage, whether it's tax law, whether it's visitation rights, whether it's Social Security benefits. It goes on and on and on. It also will implicate the immigration bill. One of the things that Leahy was going to bring up was an amendment saying that same-sex partners would be eligible for green cards. That's all nullified now. They are all under federal law. If you are married in a state that allows for same-sex marriage at this point, up until today, you will receive all the benefits of marriage that would accrue to a heterosexual couple. This is going to have implications in the military. It's going to have incredibly broad implications. The other question is the notion of reciprocity through the full faith and credit clause of the Constitution, wherein if I am married as a heterosexual man, or woman, I guess, in New York State, and I move to North Carolina. I'm trying to, it doesn't matter what state. North Carolina recognizes my marriage. However, we now have some states which have constitutional amendments saying that there is no such thing as same-sex marriage, and there are some states which essentially have no affirmative nor negative laws or constitutional amendments regarding this. It is unclear to me at this point what the implications are if you are a same-sex married couple from Massachusetts and you go to, I don't know, Texas. Clearly, Texas, because at this point, their state governments tend to be huge a-holes. They would argue that you are not, to the extent that the state gives any benefits to the institution of marriage, you would not receive them. This is going to open up a lot of court cases, and which eventually will make their way to the Supreme Court. I do not know. I mean, it is impossible to predict with the Supreme Court how they would rule on anything at this point. It depends, I guess, what their bosses in the Republican Party tell them to do. I guess we would have to listen to Rush Limbaugh to see how the Supreme Court will rule in that case. But those will be the implications. In California, Proposition 8, because the state of California did not defend, or should I say was not the plaintiff, in the case that was brought by private individuals saying that the state had no right to overturn the referendum, Prop 8. The court found that these plaintiffs could not prove that they were harmed by this in any material way, and that the Ninth Circuit, which originally heard the case, should not have taken that case either. The reason why some folks, and in fact, I think in dissent, it was Sotomayor and one other liberal justice, or maybe not, but the reason why Sotomayor, at the very least, was joined the dissent in that case was that she wanted to actually adjudicate that case on the merits rather than a procedural grounds of standing. Because there is, and we're not clear yet because this is something that has to be sort of figured out with case law, there are some implications here to the idea that you as a private individual could not establish standing in this situation. So, for instance, a state says that we're going to establish a law that says you're not allowed to put I don't know, that you're not allowed to put to pollute the rivers. I mean, some of this is moot because of federal law, but just for a moment, indulge me. You're not allowed to pollute the rivers. Corporation A sues the state and says, you can't do this. It infringes on my property rights or some other thing. And a judge finds you're correct. If there's to be a appeal of that case, and the state now decides, we're not going to appeal the decision. As an individual, I may not be found to have standing because of this precedent. Now, the thing that complicates this is that I, as an individual, might be able to argue that I can show demonstrable harm because I can no longer go swimming in that river, or I used to fish in that river, or some other harm that befalls me because of this pollution. Then arguably I have standing. It's a trickier case because, short of Jesus weeping and the potential or trying to prove that somehow if two men or two women can get married, that somehow I'm harmed by this. It is a much harder row to hoe or road to hoe in the event that you need to row to hoe a road. So that's where it becomes that becomes a question that we have yet to resolve, and is going to be resolved with cases, I would imagine, over the next 5 to 10 years, or 6 months to 5 years. Who knows what that window is going to be.